measure that some say is reminiscent of the tyranny of King George III being enacted this week, active immediately effective. Governor J.B. Pritzker signing the bill that passed both the House and Senate that limits where individuals can file constitutional challenges against state laws. There are 102 counties in the state of Illinois. And this law, now in effect, Governor J.B. Pritzker signing, would limit people to only sue in Sangamon County, which is where the capital city is of Springfield, or Cook County, which is, of course, Chicago. This is something that when I shared just the screenshot of the statement from the governor's office saying he'd signed this bill, I can't even tell. It's been seen on Twitter 100,000 plus times. It's incredible just how much activity just on that screenshot there was of people sounding off on this. But I wanted to reach out to some attorneys who have been challenging state laws on constitutional grounds, filing those in state courts. You've got, of course, the history of the COVID era executive mandates, which also couldn't be challenged in your county court. You'd have to go to Springfield or Sangamon County. Thomas DeVore, if you recall, he had a slew of challenges, challenging everything from vaccine mandates for some employees to school mask and exclusion mandates that were being leveled upon local school districts and parents, securing temporary restraining orders against those executive orders in those county courts. And then you get also the Safety Act, where states' attorneys from across the state sued the state, trying to block the implementation of no cash bail statewide. That was heard consolidated out of Kankakee County, where they got a temporary restraining order, and the law is still on hold while the Illinois Supreme Court deals with that issue. But then you get to all of the temporary restraining orders for thousands of people that attorney Thomas DeVore secured, and also Dan Calkins secured in counties that are not Sangamon or Cook County. So Democrats even saying that indeed all of those reasons are why they need to limit where you can sue your state government in state court. I talked with attorney Thomas Maag yesterday about his case down in the Southern District challenging Illinois' gun ban. But I also asked him to respond because he filed the first challenge of the gun ban in state court in Crawford County. I asked him his thoughts on how this is going to impact citizens' ability to hold their government accountable.
It reminds me of one of the crimes, quote unquote, of King George listed in the Declaration of Independence, i.e., prohibiting access to the courts and protecting the king's people by dragging people off to England for what the Declaration of Independence calls pretended trials. In my opinion, the statute is blatantly unconstitutional under due process and under access to the courts. The Illinois Supreme Court, in a similar case, brought concerning the Illinois State's, I think it was Scholarship Commission 20 years ago, said as much, that it was unconstitutional, that persons have rights to access to the courts. Obviously, this is intended to make access to the courts inconvenient and difficult. In fact, just was happenstance yesterday, we filed a constitutional case, and in count 2 of the case, put in a direct challenge to this statute and dutifully filed it in the plaintiff's home county, which is not Cook County and is not Sangamon County. And we dare the Attorney General to try to transfer the case.
And Maag said that particular case deals with firearms, and in particular a challenge of an individual having their FOID card denied because of a previous cannabis conviction based off of a U.S. appeals court's decision recently saying that nonviolent cannabis users have the right to keep and bear arms. So that aside, let's now get a reaction from attorney Thomas DeVore, who I referenced earlier was busy suing the state over the governor's ban on semi-automatic weapons, but also challenging the governor's executive orders when it comes to COVID-19 mandates. Tom, thanks for taking time with us this morning. What's your reaction to this law that's now in effect?
I just started laughing when I heard they were going to pass this bill, Greg. I mean, it's in Springfield, it's generally known as the Tom DeVore bill because this was a direct response to their losses that they suffered, not as much legally, even though that was significant, but more politically, the losses that the governor suffered and the things he was doing to try to combat the courts outside of his preferred forums. So, I mean, it was kind of laughable, but this law that they passed is 100%. And lawyers never say 100%. They'll usually say 99.9, Greg, because you never know because you're dealing with human beings, even in a courtroom. It's 100% unconstitutional. Article 6, Section 9 of the Illinois Constitution gives jurisdiction over all justiciable matters to the circuit courts, which means any type of case is heard by these courts. And it's that reason to stop the law that they just passed. It's the very essence of that article of the Constitution. And so they pass a law that says, oh, this type of case, challenging these types of things, can only be heard in 2 of the 102 counties. If you go read Article 6, Section 9, you'll realize that it's completely contrary to that. So again, there is zero doubt that law they passed is not unconstitutional. It's absolutely unconstitutional. And I'm glad Tom filed. I know the case you're talking about that Tom mentioned. We're plotting right now, but I'm going to challenge that law. And I promise you, sir, I'm not doing it in Cook or Sangamon County. And I'm like Tom Maag. I challenge the Attorney General to walk into the courtroom and say that this case can't be here because of that law. It is so laughable that it's just another example of why the Attorney General is in the pocket of J.B. Pritzker. He's in his pocket. He's a pawn because the Attorney General should have stepped up and said, you can't do this. But he doesn't because, again, he's paid off by the governor's campaign contributions. And it's sad, it's unfortunate, but this law will never stand. It'll never stand. No way. Zero chance.
So if you could, I guess, how does this impact somebody of lesser means? How does this impact somebody who doesn't have all the money in the world to fund a lawyer to be able to travel hundreds of miles, say they live in Cairo, Illinois? I mean, are they just SOL in being able to redress their grievances with their state government?
Well, it certainly was the intention of the law, right? There's a couple of points about this law. Keep in mind Governor Pritzker and his minions, because Governor Pritzker controls the Illinois General Assembly right now. He controls the Attorney General's office. He controls the legislature. And to the extent he thinks he controls the judiciary, he's found out over the last few years, fighting with people of the state through lawyers such as me and Tom, et cetera, he doesn't control the judiciary. He's trying to control the judiciary by passing this law, trying to limit these types of cases to forums that he thinks that he can politically influence, like Cook and Sangamon County. He doesn't care that people from the southern tip of Cairo, Illinois, can't file a case down there. He doesn't care. But you're absolutely right. It does limit their ability. And I'm going to bring you back in a circle, Greg. It's why there's a constitutional provision, Article 6, Section 9, that says you can't do that. The governor can't get a law passed that says, oh, if you want to sue on this type of case, you can't file it in Randolph County or Monroe County or Alexander County. You got to file it in these counties. It's so laughable. But again, the governor has no desire. He doesn't care about people's rights. He's never cared about people's rights. He only cares about pursuing an agenda, and he manipulates it with his $3 or $4 or $5 billion by getting the legislature. I mean, President Harmon and Speaker Welch, they're patsies and they're pawns, and they do whatever the man wants.
Tom DeVore joining us live here with Springfield's Morning News on WMAY, getting his reaction to the law that Governor J.B. Pritzker enacted this week, limiting where citizens can sue to challenge state laws in state court. This only deals with state court, does not deal with federal courts. But Tom, I want to get your reaction to, the Democrats when they were talking about this. They threw out terms like frivolous lawsuits or, venue shopping or judge shopping. Were you judge shopping or venue shopping when it comes to filing what they're characterizing as frivolous lawsuits?
No, of course not. It is common to file lawsuits in places to where the case that you have will get a fair shake. Right? It is laughable to think that people that live and want to bring claims in Southern Illinois are going to go to Cook County. I mean, the court system is set up in a way that where venue is proper in certain places. I didn't create the Constitution of Illinois. I didn't create the statutes that are, again, the constitutional statutes. So we filed cases in places that the law allowed us to file them. Why on earth would I have clients in Effingham County go file a case in Cook County about anything? Whether it's a constitutional challenge or to the governor's authority or the legislature's, why would I file their case up there? I'm going to file that case in where they live, where they elect judges, where those judges are responsible for the people that are bringing the challenges and the cases to court, because that's what the Illinois and U.S. Constitution provide. I'm not going to file it in Cook County where those judges don't know these people. They don't care about these people. It's not their problem because those people live 5 hours south. Of course not. I'm going to allow my clients to operate within the confines of the constitutional authority that the courts have, period. I'm not going to file it in Cook County. It's stupid. And so, again, the governor knows that. No more than the governor would file a case that he wants to have heard fairly according to what he thinks are in his best interest in Cairo, Illinois. Governor's not going to do that. He's going to file it in Cook County or Sangamon County to where he thinks he can get a fair shake. I think the governor even says where he thinks he can get an unfair shake because he can influence politically. It's not improper, Greg. It's not improper. What's improper is to limit people's authority or ability to file wherever the Constitution allows them to file. It's that simple.
Well, Tom, we'll be watching this closely, and do keep me posted if you do file a challenge to this law, and we'll definitely highlight that and get that information out there, all right?
Oh, you can tell them the challenge is coming, Greg, and there's a 0% chance that it gets filed in Cook or Sangamon County. It will be filed in a different county, I promise you. There's 0% chance that this law is going to be followed by me or any other lawyer in the state of Illinois.
Appreciate that, and we'll talk again soon, all right? Be safe.
All right. Take care. Bye.
It is Springfield's Morning News on 92.7 WMAY. Springfield.